Welcome back to my prison series. This is episode 72. Today we're going to talk about what to do when you're denied bail. This is part 2, and we are going to skim through and we are going to talk about things that other people are saying who have been in these situations. So, there are some crimes that are never allowed to be granted bail. So here's an example: things like terrorism, repeat serious offenders of past crimes, of essaying people, or murder, attempted murder. Those are like the things where you just can't really get out of those situations. So if a person is already on bail and they commit a crime, they will not be granted bail, people, for the second offense unless the court is completely confident that they won't reoffend while on bail again. There are also restrictions for Class A drug users, which include the offenders being charged for possession or intent to supply a Class A drug. So the courts, believing that drug use was the cause of the offense and the defendant refusing to participate in future rehabilitation. So I guess if you're a difficult person, that should be obvious that things aren't going to go in your favor for your case. Okay, so this person is talking about something that they've been accused of. So I guess they're saying when they got out too, it was really hard to get a job and to pass the reference check. And then they're just like, when they got out, they felt pretty hopeless, which that sounds about how people would feel. Okay, so also, if you can't afford bail, you don't have anyone to post bail for you, how long does it take to get out? Someone asked something that simple. This person's like, they live in the US and sadly they've had this experience, so they experienced the situation being talked about. And they say you usually have 3 options in these situations. Okay, so if you had no money or no one to pay it, you have to either stay in jail until the plea hearing / trial or transfer to prison. And the person was like, they chose this option because it was the cheapest and more practical in their case. And then the next option is to get a bonds loan. So in Florida, that means hiring a licensed bondsman and securing a sufficient bond. Usually a sufficient amount is 10% of the total bail. But this is just a rule of thumb, okay? And exceptions are not uncommon, like his case. And he was like, he did explore this with his attorney and it would have cost him $20,000 with a 15% interest rate. I think he was scared of having to pay that. The big thing is you do require a good collateral, which could include things like your house, possessions, and sometimes even your 401k. This isn't a desirable suggestion, and people who usually use this option are sure that they won't get any jail time and they can pay back the bond in a good time. In this case, it might take a couple of days to a week, depending on, I guess, how soon your loan is granted. A lot of your odds of being granted a loan depends on your chances of going to prison. In my case, it was a serious enough fraud case that going to prison was a certainty for me, as opposed to, say, first. I guess that person's just saying that was not going to be worthy. The next thing you can do is, if you're in that situation of not being able to afford bail, is request another bail hearing. This might mean more legal costs. Again, free attorneys are not the same thing as non. Okay, so I guess they're just saying that this is also not a good idea for people. And you need a good explanation on why you want another bail hearing. For example, if a family member got ill or there has been significant changes in your case, like someone else confessing to the crime, or you have information that can help with this or another case, this can happen on a weekly basis, but to be granted another bail hearing is an expensive and horrifying affair. Okay? So how do I live on my life when I am on bail? and knowing that I will be going to jail. That's what the person asked. So if you're on bail, it means you haven't been sentenced yet. You should be doing everything you can to show the judge that you're remorseful for what you've done. There are different things that you can do to show the judge that this is a real wake-up call for you, and instead of just, doing nothing, I guess they're just saying show you've made some serious life changes. And if you're facing certain charges like drug or alcohol, take the time to go to AA meetings, group counseling and treatment, whatever. If there was violence involved in your crime, think about an anger management class, individual counseling, whether you think it will help or not, or whether you believe in the philosophies of it or not is irrelevant. These are the kinds of things that judges want to see. Okay, so we're going to repeat that. So look, if you're facing drug or alcohol charges, okay, take the time to go to an AA meeting, group counseling, treatment, whatever. And if you are involved in some type of violence crime, think about an anger management class, individual counseling, etc. And it doesn't matter if you think it will help. Again, this is what the judge wants to see, to show that you're remorseful for the things that you've done. Also, if you're new to my channel, don't forget to like the video and don't forget to subscribe. Don't forget to check out my previous prison episodes and my death series, okay? Okay, so look, what is the process for being released on bail while awaiting trial? How is the bail amount decided and by whom? In America, a judge always decides the bail amount, no one else. The amount is decided by the seriousness of the offense. Whether anyone was injured during the offense, whether the defendant destroyed any property, in the criminal history of the defendant. Also taken into consideration is whether the defendant is employed or if he's honorably discharged veteran, his highest education level, and if he or she has a spouse or children. How long they have lived in the community, and the ties they have to the community. Judges will also take into consideration as to whether the defendant is a flight risk, and a large amount of consideration is given to whether the defendant has been on bail in other cases and failed to appear in court for scheduled court dates. Yeah, so you always want to show up to your court dates, people. It makes you look bad, and that can also give you jail time if you don't show up. So a major factor in bail amount is whether the defendant was on bail for another crime they committed the second crime. Okay, so this will result in revocation of the first bail and a no bail order entered on their file. Okay, so let's see what else they say. Is it possible to appeal a bond? Oh, wait. To appeal a denied bond. Yes, it's possible to appeal it. A denied bond in most legal systems, particularly in the United States, however, the process and likelihood of success can vary depending on the specifics of the case and the jurisdiction. Here's a general rule of the steps involved. So understanding the reasons for denial. The first step is to understand why the bond was denied. Common reasons for bond denial include the severity of the crime, a history of failing to appear in court, perceived risk to the public safety, or being considered a flight risk. File a motion for reconsideration or appeal. If you believe the decision to deny bond was unjust, you can file a motion for reconsideration or appeal the decision. This usually involves submitting a formal request to the same court or higher court to review the decision. The specifics of this process depends on the legal framework of the jurisdiction in which the case is being heard. Legal representation. It's advisable to have legal representation to navigate this process. A lawyer experienced in criminal defense can provide guidance, prepare the necessary documents, and argue on your behalf. Also, present new information or change circumstances. The appeal is more likely to be successful in those circumstances. And if you can present new information or demonstrate that the circumstances have changed since the initial bond hearing, for example, you might provide evidence that contradicts reasons for the initial denial, such as proof of strong community ties that reduces the risk of fleeing. Be prepared for conditions. Even if the appeal is successful, be prepared for the court to set conditions for the bond. These can include travel restrictions, regular check-ins with the law enforcement, electronic monitoring, surrendering of passport, and other conditions aimed at mitigating the risk of flight or danger to the community. Await the decision. After the appeal is filed and heard, you will need to wait the decision of the court. The time frame for this can vary depending on the court's schedule and the complexity of the case. Remember, the ability to appeal a bond decision and the specific process involved can vary significantly depending on the legal jurisdiction and the specifics of the case. It's crucial to have knowledgeable legal counsel to guide you through this process, okay? And present the strongest possible case for granting of bond. And you know, Diddy is currently going through this right now where he had put up so much money that he still was denied. They didn't care. They didn't want to grant it for him. So it looks like he needs to present new evidence or something showing that he's changed since then, or what he plans to do when he's released to show that he wants to work on changing. And also, if you're new to my channel, again, don't forget to like the video, don't forget to subscribe, and check out my previous prison episodes and hit that notification bell so you can know all the times that I post. So, what happens if someone is granted bail after being denied by the court? That would be unusual. If one judge denies bail, getting another to grant bail will require extenuous circumstances. Usually a bail hearing takes place after a first appearance, so the courts have had time to weigh up the circumstances around granting bail. Flight risk, threat to the public, but I guess there's the odd circumstances where a judge might grant bail after another did not. But there would be a substantial surety involved, 5 to 10,000. Violent offenders don't often get bail, and when they do, it often turns out to be a mistake where the bail is quickly revoked. Judges do try to grant bail because keeping an accused in custody is expensive. And so often, trials in an acquittal for the accused. Okay, so what is the need of bail amount if court really is willing to give bail for a certain time period? How is the bail calculated? How will a poor person pay bail amounts which in many cases is above $50,000? Bail is basically up to the judge assigned in your location of arrest. Typically, they call on the judge for this. The initial court appearance is called an arraignment or bail hearing. Okay, so bail is given at the judge's discretion. However, it must be within guidelines, usually 10% of the original bail posted in order to be released unless stated unsecured, in which you are free to leave your own, or if it's a straight bail where you must pay the full amount of the whole bail set. Guidelines are based on the number of prior convictions, the charges you have going before the judge. If you are a flight risk or other factors, bail is supposed to be reasonable. Okay? This means if you are poor, you shouldn't get a $1 million bail for a minor crime. Violent crimes have higher bail. In most cases, the judge, when setting bail, factors in the 10%, so he or she says $5,000, she knows that you most likely will put 10%, which is $500. I've seen bail at, I don't know what they mean. I guess they're saying, but they had included more numbers that people couldn't post because they couldn't have anyone post that for them. I've seen bail at 100,000. Straight bail that was posted considerably fast. That's really funny that someone got bail for that. Okay, so what factors does the court consider when deciding whether to grant or deny someone's request for pretrial release or denial of bond/bail after arrest prior to trial? Okay, so the nature of the crime, history within the community, history of failure to show up in court. Is the crime bailable? If so, what's the maximum or minimum bail. For example, if a person is accused of theft of a candy bar and has never been charged with a crime before, then there is about a 100% chance of being released without bail. Isn't that good to know, people? Okay, so alternately, if a person has been arrested for domestic assault and has a history of not showing up to court, there is a strong chance of high bail or no bail will be applied. They're making sense because they're trying to say you might not show up and you're this type of person. You might try to do something like this again to somebody else. A person accused of a crime, accused of murder, is of a lesser threat than a person accused of threat. I don't know what they mean there. The murder is obviously a big threat. So is there a way to get a bond or bail set for someone that was arrested without hiring a lawyer? In Chicago, Cook County, Illinois, the accused must be brought before a judge for a bail hearing within 72 hours of arrest. Since the accused is in custody before and during the bail hearing, he will have the services of a public defender. The PD will represent the accused for the purpose of setting bail. If the accused wants a private lawyer, he will hire or she will hire after the bail hearing. Usually on occasions, the accused's family and friends will hire a private lawyer ahead of the bail hearing. In my 38 years of criminal defense practice in Chicago, I usually got into a case after the bail hearing. One of the pre-motions I filed, if the now defendant could make bail, is a motion to reduce bail. Since the notorious Cook County Jail was and still is severely overcrowded, I was usually successful at getting my client's bail reduced. How do I live my life when I am on bail and knowing I will be going to jail? Be good to those around you. Visit your mother, do nice things for her, make sure she's well cared for while you are gone. Same for any children you have. Talk to your friends, share what you want to, make contingency plans for them to help with your mother or kids. Then if you have time left over, do some good for society. Volunteer at a nursing home or school or animal shelter. Feed the homeless, talk to a pastor, and see what other things you can do. Remorse for doing something bad involves doing some kind of payback, so the good you do will help you in this bad situation. Okay? And be kind and generous and don't expect anything in return. Read the Bible or other inspirational books and try to turn yourself around. You will be better for it, and so will everyone else around you. What is the process for getting bailed out of custody after being arrested? How long does it typically take to post bail and be released from jail? It depends on when you're arrested and what you're arrested for. If you're arrested on a Friday night for drunk driving, you usually spend the night in jail, people. Okay, you usually spend the night, and the next morning you will get to go to a regular jail cell. Monday afternoon, you go to see the judge for your bond hearing. The judge will set the bail amount to $5,000. The defendant can call the bail's bondsman from his jail cell, or a family member can call the bail's bondsman or go down and pay the bail's bondman $500, and you will get out within a couple of hours. And that's all I have for you. I hope you guys enjoyed the video. Please like, share, and subscribe, and I will see you on the next one.